topic is guerrilla tactics in international arbitration. And before I start, I would like to introduce some terms. I hope you all remember what is international arbitration, because I think there was a presentation already on this topic. So I will skip it. Now, Guerrilla is a member of an irregular armed force that fights a stronger force by sabotage and harassment. Arbitration guerrilla is one who will try to exploit procedural rules for their own advantage, seem to delay the hearing, and, if possibly, ultimately to derail the arbitration so that it becomes abortive or ineffective. Guerrilla tactics, however, should not be limited to actions intended to delay an arbitration proceedings. The idea of guerrilla tactics usually consists of the following. The respondent knows that it has failed to perform its obligations. The respondent knows that the initiated arbitration proceedings will sooner or later come to an end, and most likely the award will be against that respondent. And therefore, respondents uses various techniques which, from the standpoint of the international arbitration community, are impermissible and aimed either at getting a positive arbitral award or making it impossible to enforce the negative arbitral award. Some scholars classify guerrilla tactics into two categories: hard-type guerrilla tactics and soft-type guerrilla tactics, where hard-type we can find mostly in the criminal law field, and soft-type guerrilla tactics are staying within the confines of private law. So, hard-type guerrilla tactics. These are usually attempts at physically influencing the parties or arbitrators to cut short the arbitration. They can be divided into measures aimed against a party to arbitral proceedings, against a party's counsel, and against an arbitrator. Well, measures aimed against the party of arbitral proceedings, there is not much to tell about these measures, as they commonly involve death threats or even assassination attempts, and usually are prosecuted by criminal law. Measures aimed against a party's counsel, fortunately, are a rare occurrence, since from the position of party using a guerrilla tactic, actions against a lawyer will hardly bring about the desired result. The party may always hire another counsel whom it will be more difficult to pressure, for instance, due to that counsel's location in a safer jurisdiction. And the mere fact that there was pressure on party counsel will not invoke sympathy from the tribunal, and in the end the tribunal will work against the party using the guerrilla tactics. Next slide. A bit more on measures aimed against arbitrators, as these, if successful, tend to be most effective measures. From the point of final result, the pressure on the arbitrators could be much more effective. Such pressure can be, for example, exerted by a court passing an anti-suit injunction prohibiting not only the parties from continuing an arbitration proceeding, but the arbitrators as well. This situation often may happen if there is an arbitral proceedings where one party is some commercial body or firm, and the other party is backed up by government. Then government might press on its own courts, and they pass an anti-suit injunction. However, it is this practice is limited to a little number of countries, as it is considered unethical, and in the end it's rarely effective. More common are cases where the arbitrators are bribed or for some reason too loyal to one of the parties. From the point of view of obtaining a predictable result, an experienced guerrilla usually does not try to bribe an arbitrator tribunal that has already been constituted, but instead strives to form an arbitral tribunal that is loyal to a certain party. In a situation where an arbitral tribunal is formed by both parties to the dispute, it appears that something similar is impossible. Indeed, a guerrilla can appoint an infiltrator arbitrator, but at the end of the day, the outcome of the hearing will depend on the chairman, who, as a general rule, is jointly appointed by the parties or by the party-appointed arbitrators. So, bribing an arbitrator is not the most effective tactic, as well as reassuring that arbitrator that your party appointed is very loyal to you. This will not guarantee victory because the decision will depend on the presiding arbitrator. However, if the parties fail to jointly appoint the presiding arbitrator, the appointment is made by the arbitration institution which the parties have chosen. So, if Guerrilla guarantees the loyalty of arbitration institution, it guarantees that institution appoints a loyal presiding arbitrator, and then the decision will be in the interest of this party. This often happens in our country, as the legal legislation existing today in Russia allows any person to create a permanent arbitration court. The creation of a court of arbitration is not subject to any special registration or any sort of monitoring. As a result of this, at present in Russia there are about 300 permanent arbitration institutions. Arbitration courts are established by chambers of commerce, stock markets, business associates, major and middle-sized companies. Sometimes parties, when discussing a contract, pay little attention to the arbitration clause. Sometimes, resulting from the fact that the party has a weaker negotiating position, it is compelled to agree to a proposal from the stronger party, insisting on a certain arbitration institute. This can be illustrated by an example. In 2002, an arbitral tribunal acting under the rules of the arbitration court at ZAO TPK made an award in favor of ZAO TPK. Some company, ZAO TPK, created an arbitral tribunal, and in all its contract it placed an arbitration clause, which meant that all disputes will be resolved by this arbitral tribunal created by ZAO TPK. However, the decision of this arbitral court was overruled later in Russian state court, as there were doubts about the impartiality of the chairman. That's it for the hard guerrilla tactics. Now about soft type of guerrilla tactics. These are commonly actions by a party which stay within the bounds of private law, but nonetheless are aimed at disruption of the arbitration proceedings. The goal of such tactics is either to delay the anticipated negative arbitral award or to create grounds for setting aside the negative arbitral award, or for refusing to recognize it and enforce it. There are generally two type of tactics within this soft tactics, which may be called notification games and delay games. Notification games are aimed at creating grounds for setting aside the negative arbitral award in national courts. And experienced arbitrators pay quite a lot of attention to the issue of proper notice to the party which is not taking part in the arbitration proceedings. Nonetheless, sometimes Russian courts display extreme formalism applied to the matter of serving notice of arbitration proceedings, acting by the analogy of serving notices while cases are being considered in state courts. And therefore, the proof that a respondent has been notified that arbitrators consider sufficient might turn out to be insufficient for Russian courts. In other words, the party does not come on the hearing on the arbitration, and later in national court it tries to prove that it was not aware of these proceedings and therefore could not attend it. And on these grounds, they ask state courts to neglect the arbitral award. Delay games are even more common, and it's very popular, well, sport in Russian arbitration as well as in Russian state courts. And there is even a saying that as long as the case is delayed, it isn't lost. If a party assumes that it will lose a case, it might strive to delay something undesirable. During that time, other events may occur. For example, a debtor might go bankrupt or transfer its assets to a third party. Therefore, a formal win in the case under arbitration will hardly be able to bring any real benefit to the claimant. Techniques for dragging out an arbitration proceedings can be all of the kinds. The most innocent technique is to request an extension of the term for filing a submission. As a rule, such requests are granted. However, repeated extension of the terms could lead to rescheduling the previously agreed date of the final hearing, and that is in turn might lead to a serious delay in the proceedings. It also happens that a party changes its legal counsel. Indeed, it is the right of the party to determine whether or not it likes this or that legal advisor. However, if the change in advisor occurs not long before the hearing, it is very likely to entail a rescheduling of the hearing itself. Furthermore, a party may appoint a loyal arbitrator who might also withdraw from the case, for example, not long before the hearing. The reasons for such a resignation can be all of the kinds: illness, lack of time, an exposed conflict of interest, and so forth. And this can hardly be anyway prevented or prosecuted by the tribunal. In this case, the hearings are hardly likely to take place. Well, that's it. Thank you for your attention. Any questions?
Yes, there's one. I'm very interested about the hard Guerrilla, yeah? My question is next, I'm following. Is the hard Guerrilla illegal? Because I saw the bribery, I saw something like
No, that is the distinction between hard Guerrilla and soft Guerrilla. Hard Guerrilla is almost always illegal.
Always illegal.
Yes.
So, for example, I can, I don't know, take a pistol and catch the arbitrator and says, do it like I want. And this will be a hard Guerrilla, yeah?
Exactly.
Okay, thank you. I will think about it.
Sorry, I have one more question for you. Could you please tell me, I didn't understand these rules or these opinions, they are useful just for the commercial arbitration, or we may use it, for example, for the sportive arbitration or another type of alternative dispute resolving.
You mean this guerrilla tactics?
Yes.
Well, some of them certainly may be used because they are, well, universal. You can, if there is a dispute, it doesn't matter how you resolve it, you can always go and threat and make him withdraw his, I don't know, his position and withdraw from these proceedings at all.
And tell me please, these tactics, it is legal tactic or little bit with little some of illegality?
Well, again, they can be hard, which are illegal, and soft, which are legal but unethical, unsportive, and will gain you no support of the arbitrators.
Because as I understood from your answer, we may qualify bribe as present, as deposit, as credit to for our arbitrator, with whom we are for whom we are use this tactic.
Well, it usually doesn't matter how we call it, because it still will be a bribe, and it differs from the I suppose it differs depending on the rules which are applied to the proceedings, but I think it is generally forbidden to give any presents or credits or anything to the arbitrator, because it will make him impartial, and the award could not be forced on this ground.
Thank you very much.
Any more questions? Thank you.